And culture evolves in a similar way, but the elements aren't genes, they're memes. Ideas, behaviors, skills. Memes are copied, transformed, and combined. And the dominant ideas of our time are the memes that spread the most. This is social evolution. Copy, transform, and combine. It's who we are, it's how we live, and of course, it's how we create. Our new ideas evolve from the old ones. But our system of law doesn't acknowledge the derivative nature of creativity. Instead, ideas are regarded as property, as unique and original lots with distinct boundaries. But ideas aren't so tidy. They're layered, they're interwoven, they're tangled. And when the system conflicts with the reality, the system starts to fail. For almost our entire history, ideas were free. The works of Shakespeare, Gutenberg, and Rembrandt could be openly copied and built upon. Influential thinkers proposed that ideas are a form of property, and this conviction would eventually yield a new term, intellectual property. This was a meme that would multiply wildly, thanks in part to a quirk of human psychology known as loss aversion. Simply put, we hate losing what we've got. People tend to place a much higher value on losses than on gains, so the gains we get from copying the work of others don't make a big impression. But when it's our ideas being copied, we perceive this as a loss and we get territorial. For instance, Disney made extensive use of the public domain. Stories like Snow White, Pinocchio, and Alice in Wonderland were all taken from the public domain. But when it came time for the copyright of Disney's early films to expire, they lobbied to have the term of copyright extended. Artist Shepard Fairey has frequently used existing art in his work. This practice came to a head when he was sued by the Associated Press for basing his famous Obama Hope poster on their photo. Nonetheless, when it was his imagery used in a piece by Baxter Orr, Fairey threatened to sue. And lastly, Steve Jobs was sometimes boastful about Apple's history of copying.
We have, always been shameless about stealing great ideas.
But he harbored deep grudges against those who dared to copy Apple. I'm going to destroy Android because it's a stolen product. I'm willing to go thermonuclear war on this.
The origin of copyright law takes us back to 1710 and Queen Anne, the monarch who had just overseen the unification of England and Scotland into the then brand new Great Britain. Also on our busy schedule was the Statute of Anne, the very first copyright law. It gave authors control over who could make copies of their books or build on their work for a limited period of time. Later, a group of rebellious colonists thought that the Statute of Anne was a good idea, and so copy-pasted it into their own constitution, giving Congress the power to promote the progress of science and useful arts by securing for limited times to authors the exclusive right to their respective writings. Basically, copyright is a contract between authors and society. If you promise to make more stuff, we promise not to copy it or build on it for 28 years. Here's an example from the modern day. Let's say you're trying to be a director and you're looking for a project to get started. Harry Potter is a story you'd love to remake, but since J.K. Rowling published The Sorcerer's Stone in the United States in 1998, it still has copyright protection, so you can't use it. Instead, you need to find something from a long time ago. For example, George Lucas released Star Wars: A New Hope in 1977. That's more than 28 years ago, so great, get filming. Alas, no. While Star Wars should have lost copyright protection in 2005, it's actually copyrighted until 95 years after publication, not 28. So you can't use it unless Lucas lets you. Why does his copyright last for ages? Well, as long as there has been copyright, there have been authors arguing that it's too short. And perhaps they're right. How's a poor guy like Lucas supposed to turn a profit in the mere 28 years between 1977 and 2005?
Copyright it's just something that protects original works of authorship that are fixed in a tangible form of expression. Now, one of the interesting things I discovered about copyright is that no one needs to actually apply for it. In fact, copyright is actually automatically given to you. So as soon as you write down some sort of a unique pattern of words or pattern of colors on a canvas, which would be a painting, I guess, then that automatically becomes copyrighted to you.
When we copy, we justify it. When others copy, we vilify it. Most of us have no problem with copying as long as we're the ones doing it. So with a blind eye toward our own mimicry and propelled by faith in markets and ownership, intellectual property swelled beyond its original scope, with broader interpretations of existing laws, new legislation, new realms of coverage, and alluring rewards. In 1981, George Harrison lost a $1.5 million case for subconsciously copying the doo-wop hit He's So Fine in his ballad, My Sweet Lord.
I really want to know you. Really want to go with you. I don't know how I'm gonna do it, but I'm gonna make it mine. Be the envy of
Prior to this, plenty of songs sounded much more like other songs without ending up in court. Ray Charles created the prototype for soul music when he based I Got a Woman on the gospel song It Must Be Jesus.
There's a man be Jesus, going around be Jesus, taking names be Jesus, oh Lord.
Say I got a woman way over town, good to me. Oh yeah, she give me money.
Starting in the late 90s, a series of new copyright laws and regulations began to be introduced, and many more are in the works. The most ambitious in scope are trade agreements. Because these are treaties and not laws, they can be negotiated in secret, with no public input and no congressional approval. In 2011, ACTA was signed by President Obama, and the Trans-Pacific Partnership Agreement, currently being written in secret, aims to spread even stronger US-style protections around the world. Of course, when the United States itself was a developing economy, it refused to sign treaties and had no protection for foreign creators. Charles Dickens famously complained about America's bustling book piracy market, calling it a horrible thing that scoundrel booksellers should grow rich. Patent coverage made the leap from physical inventions to virtual ones, most notably software. But this is not a natural transition. A patent is a blueprint for how to make an invention. Software patents are more like a loose description of what something would be like if it actually was invented. And software patents are written in the broadest possible language to get the broadest possible protection. The vagueness of these terms can sometimes reach absurd levels. For example, information manufacturing machine, which covers anything computer-like, or material object, which covers pretty much anything. The fuzziness of software patents boundaries has turned the smartphone industry into one giant turf war. 62% of all patent lawsuits are now over software. The estimated wealth lost is $500 billion. The expanding reach of intellectual property has introduced more and more possibilities for opportunistic litigation, suing to make a buck. Two new species evolved whose entire business model is lawsuits: sample trolls and patent trolls. These are corporations that don't actually produce anything. They acquire a library of intellectual property rights, then litigate to earn profits. And because legal defense is hundreds of thousands of dollars in copyright cases and millions in patents, their targets are usually highly motivated to settle out of court.
Now, for something to be property, the only attribute it really needs to have, it needs to be rivalrous. Whatever said piece of property there is, I can't be able to use it in the same way as you can simultaneously. So for instance, I can't eat the same apple as Joe Bob at the same time. We physically, the laws of physics prevent us from doing this. Well, if I make a statue, I should own that statue, right? If I take my stuff and make a statue out of it, then I should own that statue. Well, you don't own the statue because you turn your stuff into a statue. You own your statue because you own the materials you used to build it in the first place. And the case I have here is a tree house. So if I went to my neighbor's house, took his wood, and then used that to build a tree house of my own, just because I transform that wood into something new, I produce something new, doesn't make it mine because they're originally his resources. So the fact that through original appropriation or trading, how we acquire property legitimately, those two ways of acquiring property are sufficient to cover things which we should rightfully own if we produce them. So it's not that we don't own some things that we create, it's just that it's not an independent right. Just like labor is not an independent right.
Let's say a guy invents a better light bulb. His price needs to cover not just the manufacturing cost, but also the cost of inventing the thing in the first place. Now let's say a competitor starts manufacturing a competing copy. The competitor doesn't need to cover those development costs, so his version can be cheaper. The bottom line, original creations can't compete with the price of copies. In the United States, the introduction of copyrights and patents was intended to address this imbalance. Copyrights covered media, patents covered inventions. Both aim to encourage the creation and proliferation of new ideas by providing a brief and limited period of exclusivity, a period where no one else could copy your work. This gave creators a window in which to cover their investment and earn a profit. After that, their work entered the public domain, where it could spread far and wide and be freely built upon. And it was this that was the goal, a robust public domain, an affordable body of ideas, products, arts, and entertainment available to all. The interdependence of our creativity has been obscured by powerful cultural ideas, but technology is now exposing this connectedness. We're struggling legally, ethically, and artistically to deal with these implications. The belief in intellectual property has grown so dominant, it's pushed the original intent of copyrights and patents out of the public consciousness. But that original purpose is still right there in plain sight. The Copyright Act of 1790 is entitled An Act for the Encouragement of Learning. The Patent Act is to promote the progress of useful arts. The exclusive rights these acts introduced were a compromise for a greater purpose. The intent was to better the lives of everyone by incentivizing creativity and producing a rich public domain, a shared pool of knowledge open to all. But exclusive rights themselves came to be considered the point, so they were strengthened and expanded. And the result hasn't been more progress or more learning, it's been more squabbling and more abuse. We live in an age with daunting problems. We need the best ideas possible, we need them now, we need them to spread fast.
You suddenly find yourself in a situation to where you could be vulnerable to many conflicts of rights. And I'll give you an example. Let's say I'd independently invent this new and improved mousetrap, right? And someone else invents the same mousetrap later down the road, and they get a patent for it and they start selling it. Well, because they have a patent, they can actually prevent me from selling my mousetrap. And the same thing with books. If I'm writing a book and it has a very similar plot to someone else's, then they get to tell me to not disseminate that, to not sell it, to whatever. So basically what the patents and the copyrights are doing is they're a way that individual people can limit how other people dispose of their own property. Now, as you know, as what property rights covers, pretty much you can dispose of your property however way you wish, as long as it does not interfere with anyone else's. So we have this comic here. I think it's kind of illuminating. We have this guy. He says, if I steal your CD, then you don't have any more, and that's legitimately theft. It's the rivalrous nature. He had a CD. He doesn't have it now, so it's been stolen. Okay, cool. Well, if now the guy on the left I think is Mimi, and the guy on the right is Eunice. So if Mimi copies Eunice's CD, Eunice still has it. He still has a CD. Nothing's happened to it. He still has access to it. It's just now Mimi has one too. So because his act of copying didn't deny Mimi access to his own property, then nothing has been stolen. He did not deny him use of his own property. Therefore, it is not theft. And this act of copying, and what this implies is really that information is not ownable, because information can be infinitely reproduced, infinitely multiplied. I think Thomas Jefferson even mentioned the analogy of a flame. If you have a candle with a flame on it, and I light my candle with that same flame, that takes nothing from your flame, but I have a flame now too. So basically, by me copying something does in no way deny you of the use of your property, and therefore is not theft. So the conclusion here is information is unownable since it's infinitely reproducible, and copying is not theft. And to try to say otherwise, to get someone, to deny someone creating an invention that's patented, or to not write certain song lyrics or not use a certain trademark, is to dictate to them how to dispose of their property, which we see as a conflict with property rights. The claim goes, for the utilitarians, whether they be libertarian or whatever else, is that by giving inventors or original creators this monopoly incentive, meaning that if they create something, we're giving them a temporary monopoly on it and the royalties for using it, we're actually incentivizing more innovation. And if we have more innovation, then we're having more inventions, and if we have more inventions, it's going to increase technology, and then we're going to become, it's going to maximize our wealth, basically. We're going to become, on the net, more prosperous, right? But they never actually consider the cost and the unintended consequences, and we'll go through those right now. So I'm gonna act like a utilitarian now, push the principles aside, and let's look at the strict costs and benefits of intellectual property. Now, what's one cost? Well, it's the suppression of ingenuity. But wait, that doesn't make sense, because I thought the whole reason we did this was to incentivize innovation. Well, that's true. However, even though the prospect of a monopoly on your invention is an incentive, you also have to realize that these inventors are now denied using all the ideas and all the patterns of information that would have been available to them had they not been patented by other people. So pretty much everyone who has a patent already while that inventor is trying to invent something, all the patents that exist and all the copyrights that exist are now pieces of information that this inventor cannot use when developing his own invention. So that fact is going to actually decrease or degrade his whether it's the uniqueness of his invention, or whether it's the utility of his invention, or whether it's the amount of inventions he's able to make because of that. It's some way, somehow going to degrade the number of inventions and their effectiveness, because he doesn't have all the information at his disposal. He can only use certain pieces of information. The next one is the monetary costs of not only the administration but also the enforcement. Okay, so now we have to hire up a bunch of bureaucrats. We have to think of very complicated patent office and patent bureaucracy and red tape to get things pushed through. Of course, we all know that to apply for patents costs money, and this is costly. And the more we spend on things like the bureaucracy and government things, is less money that we could be spending in the actual free market economy, is less money that we could be spending on research and development and what have you. And then, of course, the cost of litigation. This is probably one of the biggest ones. Now, because people are vulnerable to being sued if they are infringing someone else's patents, this has a dual effect. Not only are people going to get patents for an offensive purpose to prevent other people from trying to quote-unquote make a buck off their idea, but they also are going to be prompted to get them for defensive purposes. Maybe Company X doesn't want to get patents to use them against others, but they just want to get a patent anyway in case someone else gets a patent on what they were going to patent on this invention they did have, to prevent them from being used against themselves. So, for instance, let's say that Company A invents this new kind of cog, and it's great. Well, Company A, even though it has no intention of suing anyone else for patent infringement, is going to still get a patent on that cog, because in case someone else makes that same cog and gets a patent, then that second person can sue them for using it. So what we see here is many millions of dollars of hiring lawyers to write up these patent applications of rewards and damages on the grounds of patent infringements, copyright infringements, trademark infringements, what have you. And this is all money that could have gone to research and development, which could have gone towards inventing, which could have gone towards just spending in the free market. So already we're seeing significant cost to the economy as a whole. Alright, the next thing is a small business vulnerability. Now, what a lot of businesses do is pretty much they get a bunch of patents, and this is especially true in like the software community. They get a bunch of patents. They're like, we'll say Microsoft, for instance, gets a bunch of patents. Apple gets a bunch of patents, and it's kind of like this mutually assured destruction thing. Hey, if you sue me for one of your patent infringements, I'll sue you. So they kind of come to a stalemate. However, the small businesses don't actually have the capacity to obtain the patent arsenal, if you will, in order to make them immune and give their own selves this mutually assured destruction defense. So these small businesses are inherently a much greater risk than the big businesses because they simply can't afford these patents. So this is another huge reason why these intellectual property things like patents and copyrights are a huge hamper to the economy. And then finally, the other cost that's certain, and again, all these costs are certain. The other cost that's certain is the cost for liberty, like we discussed before. If you get a patent, that means I can't use my stuff in a certain way because now you have the right not to build something, but to exclude others from building. That's what a patent is not to build something, but to exclude others from building that thing. Okay, so what are the benefits that are claimed? Well, there's a claim that there's increased innovation. Now, there's been no actual, virtually no actual study that has showed conclusively that having intellectual property increases net innovation. And there's also been no conclusive study that proves that it has increased net prosperity within any country or economy. There's been a lot of ambiguity. And there's even been some studies that have said that it actually suppresses overall innovation and prosperity. So with ambiguous benefits, unproven benefits, but proven and solid costs, to the utilitarian, you would think they'd be against intellectual property. And furthermore, if it's a utilitarian and they're claiming that intellectual property creates increased innovation and increase the net prosperity, then that's a positive claim, which the burden of proof falls on the person making those claims. So since those claims have not been proven, we cannot see any way how they could justify degrading our liberties and incurring these costs upon ourselves in order to uphold this intellectual property. Okay, so what are some common objections? Well, we have three main ones. The first one is free riders. We'll take the example for a rock band. Like, hey man, I wrote the songs, I played them on my guitar, I beat my drums, I put the energy into it, I made the CD, someone else bought it, and now that guy bought it, but someone else burned it from him. He didn't spend anything. So the guy is free riding off of my efforts creating the song, and the guy who bought it, because he had to buy it, but the guy who burned it doesn't. So these are free riders. Free riders. Okay, well, yes, free riding is an issue. However, in this free market, when we want to stick to property rights as being the source of all rights, just because someone might be losing a potential profit does not justify infringing on everyone's property rights through the use of employing patents and copyrights. Now, an example I can use of how entrepreneurs have been able to get around this and be able to secure their profits and prevent free riding is the drive-through theater. When the drive-through theaters first came about, they had big speakers, and people they would find would sit outside the fences of the drive-through theaters and watch the stuff and free ride off of their movies. Well, in order to get around this, they started installing individual speakers for the cars. And this cost more money, and that was considered an exclusion, a cost of exclusion. So there's an extra overhead cost of exclusion, and they have it's their responsibility to create the methods and pay for the cost of these exclusion. These actually exclusion methods. So I think we beat that one to the pretty much to death. So we'll move on to the next. What if someone puts his or her name on my work? Okay, well, there's two ways this can happen. We'll use the book example. So let's use the example that I put my name on your work and published it as my own. Well, first of all, this would be an issue, and this could be taken care of under the grounds of fraud. So because if they're buying the book because they think it's written by me but it's really not, that's clearly a case of fraud. So the fraud claim would clearly be sufficient, and the intellectual property existence would be kind of superfluous. And the other thing is, well, maybe he puts my name on my work, but he publishes it under a different publisher that I didn't authorize, and I'm not getting money back for it. Well, this is an issue, but you have the advantage of being first to market, and there's other ways to be able to have uniquely identifying things to yourself. People tend to tend to view the publisher that the original creator chose as more credible, has a better reputation. You can sign the books if you want to. You can go to book signings. You can read your book aloud to people in public or whatever. The point is, it's really irrelevant how you get around these free writing problems or how you get around to potential fraud. What's mostly important is that we retain the integrity of our property rights. And I think as we see these issues, these potential issues, the free market has much more than enough capacity to take care of them. And they really are just technicalities when it comes down to it. And finally we have, well, the R&D cost becomes disincentives. Let's say that this is for pharmaceutical companies. They spend millions of dollars researching something to make a pill, and they have to cover the cost of research and development and the production of the pill, or someone else copies the pill. All they're paying for is the cost of production, and they're inherently at a disadvantage. Well, again, they have the first to market thing, they have the credibility reputation thing. They're pills, so I think I would want to buy them from the original source, not through some copycat, however irrational that might be. But those things do matter to consumers. But again, all this is really kind of irrelevant. The important thing to remember is respecting property rights, which in essence is respecting all people's liberties, is the number one thing we should be looking at. And once we start making these arbitrary claims and use consequentialism to justify government coercion and correcting some of these seeming issues, which we don't give the free market enough faith to take care of it on its own, then we're going to start seeing going down that slippery slope and starting degrading everyone's liberties. And that's when tyranny ensues.
After all, there was only the theatrical release of A New Hope, and the theatrical re-release in 1978, and again in 1979, and 1981, and 1982, and then there was the 1982 VHS and Betamax releases, the 1984 broadcast television release, the 1985 Laserdisc release, the 1989 widescreen Laserdisc release, the 1990 VHS re-release, the 1992 widescreen VHS release, the 1993 Laserdisc re-release, the 1995 VHS re-release, the 1997 special edition theatrical release, the 1997 VHS special edition release, and the 2004 DVD release.
The act of creation is surrounded by a fog of myths. Myths that creativity comes via inspiration, that original creations break the mold, that they're the products of geniuses, and appear as quickly as electricity can heat a filament. But creativity isn't magic. It happens by applying ordinary tools of thought to existing materials, and the soil from which we grow our creations is something we scorn and misunderstand, even though it gives us so much, and that's copying. Put simply, copying is how we learn. We can't introduce anything new until we're fluent in the language of our domain, and we do that through emulation. For instance, all artists spend their formative years producing derivative work. Bob Dylan's first album contained 11 cover songs. Richard Pryor began his stand-up career doing a not very good imitation of Bill Cosby. And Hunter S. Thompson retyped The Great Gatsby just to get the feel of writing a great novel. Nobody starts out original. We need copying to build a foundation of knowledge and understanding. And after that, things can get interesting. After we've grounded ourselves in the fundamentals through copying, it's then possible to create something new through transformation, taking an idea and creating variations. This is time-consuming tinkering, but it can eventually produce a breakthrough. James Watt created a major improvement to the steam engine because he was assigned to repair a Thomas Newcomen steam engine. He then spent 12 years developing his version. Christopher Latham Scholes modeled his typewriter keyboard on a piano. This design slowly evolved over 5 years into the QWERTY layout we still use today. And Thomas Edison didn't invent the light bulb. His first patent was improvement in electric lamps, but he did produce the first commercially viable one after trying 6,000 different materials for the filament. These are all major advances, but they're not original ideas so much as tipping points in a continuous line of invention by many different people. But the most dramatic results can happen when ideas are combined. By connecting ideas together, creative leaps can be made, producing some of history's biggest breakthroughs. Johann Gutenberg's printing press was invented around 1440, but almost all its components had been around for centuries. Henry Ford and the Ford Motor Company didn't invent the assembly line, interchangeable parts, or even the automobile itself, but they combined all these elements in 1908 to produce the first mass-market car, the Model T. We're all building with the same materials. Sometimes by coincidence we get similar results, but sometimes innovations just seem inevitable.